This is a continuation of a series of videos that we're doing here on exploring the options that a consumer has to resolve their foreclosure case. We talked earlier about short sale, then we talked about modification, and now in this video we're going to talk about deed in lieu. Many of the options that are presented for consumers to resolve a foreclosure case or to get out of their problems with a mortgage even before foreclosure is filed don't do anything at all for the consumer. And that can be the case with a short sale if they don't get a proper waiver of deficiency and the tax treatment and the debt that's associated with it isn't dealt with. Modification may not be a good idea for a consumer because that modification may result in additional fees, penalties, and won't resolve the underlying problem. It may just be an extended pretend, and that's another thing we talked about in the video. Today we're going to talk about deed in lieu and whether or not a deed in lieu is a good option for a consumer. Now, just like in all the other prior videos, the primary problem that exists with deeds in lieu is that the vast majority of consumers are talking with bank representatives or attorneys for banks without having proper advice from tax professionals or attorneys that represent that consumer's interest. Now, in many cases, a short sale does absolutely nothing for the consumer and oftentimes only does benefit to the realtors and the banks that are involved in that transaction. But for some folks, a deed in lieu is an option that's presented as a way to resolve a foreclosure case. And what a deed in lieu is it's just simply deeding the property back over to a bank. It's D-E-E-D space I-N lieu, L-I-E-U. And that means that in lieu of a foreclosure judgment, I'm going to deed the property back over to the bank, and now the property will become the problem of the bank. For some folks, that can be a good idea. You can just wipe your hands clean, walk away, and you've got no more troubles. But if those deed in lieu agreements aren't reviewed properly with an attorney that knows the circumstances of that consumer, again, that can come back to haunt the consumer later. We've had transactions where a consumer thought they were off the hook, that the property had been deeded away, and they had no more liability, when in fact that's not the case. Importantly, and this is especially a problem now, with the advent of the Mortgage Debt Relief Forgiveness Act, that consumer can be faced with additional tax liability that didn't exist prior to the deed in lieu. Again, just like with all the other potential options, if you don't have an experienced consumer defense attorney reviewing the case with your specific facts in mind, you're just not getting good advice, and there's potential liability down the road. So the advice here, just like the other videos in this series, is get the advice of an experienced consumer defense attorney that can look out for your interests, not of the bank or the other parties involved in the transaction.